It happens more than you might think. A report alleging child maltreatment is made to Child Protective Services. They show up to investigate, and after conducting a safety assessment, the CPS investigator decides the children can't safely remain in the home. The CPS investigator offers an ultimatum. Either you suggest a kinship caregiver the children can be placed with, or they'll have no choice but to take your case to court and place your children in foster care. Legally, these are considered voluntary placements, known informally as hidden foster care. Hidden because while it's not technically foster care by court order, it is a highly coercive out-of-home placement. The parent agrees to the placement. There is no court order, just a signed agreement between the parent or parents and CPS. There's no oversight other than CPS, and the kinship caregivers receive no financial support. If the kinship placement is found unsuitable, another kinship caregiver may be identified as suitable, or a petition can still be filed in court, and the children may end up in foster care anyway. There's no legally bound time frame for this, and since court isn't involved, there's no right to legal counsel or other assistance. Even if a kinship caregiver is suggested, CPS still has to approve the placement. This means an informal home study and background check for all household members, which may be performed prior to placement and sometimes soon after placement. In hidden foster care, this does not usually lead to licensure as a foster family, which is why no funding is provided. It's unclear just how many children are in hidden foster care placements, how long these placements last, and how to rein in this practice. Some states have limits on how long a placement can last without a court order, but those only cover involuntary placements. If CPS comes to your door and gives you the option of involuntary placement or voluntary kinship placement, we at CPSprotect Consulting Services advise requesting time, maybe a few days, to review the agreement yourself with an attorney and/or one of our child welfare consultants. More often than not, CPS will agree to this. If your attorney or child welfare consultant advises you, this time may also be used to identify a placement nearby that meets the standards of CPS without signing the voluntary placement agreement at all, reduce the duration of involvement, and possibly avoid hidden foster care altogether. However, some CPS investigators may inflict pressure regardless. If you get a CPS investigator who does inflict pressure for placement despite your request to review, and you aren't certain CPS is bluffing and are prepared to risk court involvement, we recommend consenting to hidden foster care in the moment. It is much easier and less expensive to bring your child home from hidden foster care than it is to reunify after involuntary placement and the resulting legal proceedings. Hidden foster care is an unchecked practice without solid data on prevalence and no oversight other than CPS itself, since no one is keeping a record of its use. This is a problem, as it capitalizes on some of the most coercive, murky aspects of the entire child welfare system. Fortunately, there is hope that hidden foster care will be addressed in the coming years. While in an ideal world, out-of-home placement would never need to be a thought, we do not live in that ideal world. Don't wait until CPS shows up at your door. Don't wait until you're threatened with hidden foster care. Don't wait until you're taken to court. Parental rights matter. Prepare now and have the expert team you can't be without on your side every step of the way with CPSprotect Consulting Services. Visit CPSprotect.com or call toll-free at 844-633-KIDS. CPSprotect Consulting Services, saving children, preserving families.